Hey, for educational and entertainment purposes, let's explore South Africa's FMD vaccine showdown using Freight News reporting. It's a massive clash over foot and mouth disease. We've got desperate private farmers squaring off against rigid state control. The battle lines? Farming groups like Sakeliga demanding private vaccines, taking on Agriculture Minister John Steenhuisen. Initially, the government totally blocked private help, insisting vaccination is a strictly controlled state veterinary act. But then, the Pretoria High Court shattered that deadlock. They stepped in with an urgent interim order. The judge basically forced the minister to finalize a vaccination scheme by April 17th and pay up. At the 11th hour, the state proposed this draft framework allowing for actual private veterinary oversight. The catch? Internal minutes reveal they only rushed this draft to bolster their own legal defense. Sakeliga saw right through it. They welcomed the deadline, sure, but slammed the draft's massive limitations. They argue the state still totally dictates imports and clings to sweeping, centralized control over farmers. Hitting back, Steenhuisen argues tight state coordination is absolutely essential to protect those critical international export markets. He proudly pointed out the court explicitly denied farmers completely unregulated private procurement. The state's ultimate goal here? Tracking every single dose, ensuring vaccine integrity, and keeping strict disease control. But check out this timeline. The real climax is that rapidly approaching April 28th court date. Interestingly, massive state entities like the national vaccine manufacturer actually surrendered, agreeing to abide by the court. So now, only the minister and a few top agricultural directors are left fighting this in court. Farmers pledged to keep fighting, arguing there's literally no legal reason they can't protect their own herds. So, will this new scheme finally cure the crisis, or just trigger more lawsuits on April 28th? South Africa's agricultural heartland is currently facing a silent, rapid-fire disaster. Foot and mouth disease, a highly contagious virus, is tearing through livestock across the country. The stakes are immediate and economic. When an outbreak hits, international trade partners lock their doors. These trade restrictions threaten to freeze the country's entire agricultural export market. The obvious defense is vaccination. But for years, South African farmers have been legally barred from protecting their own herds. The procurement and distribution of FMD vaccines has been held as a strict state monopoly. This map shows the result of that centralized control. While the virus, indicated by these expanding red zones, spread rapidly, the state's distribution funnel remained choked. In provinces like KwaZulu-Natal, 9 out of 10 commercial beef farmers were left with no access to the vaccine. By criminalizing private procurement, the government forced the entire industry to rely on a supply chain that had already collapsed. This rigid state monopoly transformed a manageable animal health issue into a systemic threat to the national economy. The figure at the center of this bottleneck is Agriculture Minister John Steenhuisen. His department holds the authority to regulate the country's FMD response. There is a deep irony in this position. Steenhuisen leads a political party built on the platform of privatization and deregulation, yet his ministry aggressively fought to prevent the private sector from helping to source these vaccines. While commercial farmers employ specialized veterinary teams, the highest levels of the ministry dictating their actions often lack direct veterinary or agronomy qualifications. Rather than collaborating with private industry, the state doubled down on its control. In court papers, the department insisted that vaccination is a controlled veterinary act only to be performed on the specific instruction of the state director. In the heat of an urgent crisis, the government prioritized the protection of its bureaucratic authority over free market logic or the survival of the industry. With the state system paralyzed, civil society organizations took action. Sakeliga, SAAI, and Free State Agriculture launched an urgent legal application to strip away the government's exclusive control over vaccine procurement. The Pretoria High Court ruled against the state. The judge rejected the government's claim that managing foot and mouth disease must remain an exclusive act of the state. The court issued an interim order that allows livestock owners to utilize private, unsupervised vaccination for the first time. Farmers can now hire their own veterinarians to oversee the process directly on their property. The ruling established a strict legal mandate. The minister must publish formal regulations for the scheme by April 17th, and the state must pay the application's legal costs. This legal victory proved that a government monopoly loses its standing when it fails to perform its duty. The court effectively recognized that the state's procedural delays were causing irreparable harm. The ministry fought the private sector until the morning of the hearing. It only filed a draft Section 10 scheme as a last-minute concession when faced with an imminent court defeat. On the surface, the draft is a win. It allows private veterinarians appointed by livestock owners to direct the administration of FMD vaccines without state supervision. However, look at the proposed process. Vaccine importation and distribution are still routed through a government committee. A farmer's request gets stuck in this cyclical state loop. This allows the minister to retain sweeping powers, reserving the right to halt private procurement at any time. Converting a direct state monopoly into a centralized state committee doesn't solve the supply bottleneck. It simply rebrands the obstruction while keeping the state in the driver's seat. Despite those bureaucratic hurdles, farmers now have a direct legal pathway to defend their herds. They have the right to privately source and administer approved vaccines with their own veterinary teams. To maintain national biosecurity, this framework includes strict reporting rules. On this timeline, farmers must provide 5 days' notice before vaccinating. Once completed, a mandatory report must be submitted within 14 days. This proves that the state doesn't need to control the entire supply chain to ensure safety. Private industry can handle the logistics while still meeting rigorous national health safeguards. Empowering the private sector with clear reporting protocols provides faster results and better data than a centralized state system that had already failed to perform. This crisis reveals a dynamic often missed in the media. It shows how even supposedly pro-market politicians will cling to broken state monopolies until they are forced by a court to let go. The next major milestone is April 28th. The parties will return to court to review the finalized regulations and ensure the minister hasn't inserted new, unlawful obstacles into the scheme. The organizations behind this case, Sakeliga, Saai, and Free State Agriculture, have already committed to filing further interdicts if the state attempts to reimpose its monopoly through the back door. This legal victory is a blueprint for civil empowerment. It proves that when centralized bureaucracy breaks down, a resilient private sector has the power and the legal right to step past the state and secure the country's future.
Picture this. You're looking out over the sunlit, sweeping savannas of South Africa. Grazing across these massive landscapes are millions of head of livestock. They were quite literally the lifeblood of the nation's agricultural economy. But hovering over this idyllic scene is a microscopic, devastating threat: foot and mouth disease, or FMD. When an outbreak hits, everything just stops. Exports freeze, borders close, and farmers' livelihoods are instantly pushed to the brink. Now, how you fight that disease, and more specifically, who actually gets to hold the syringe, has just sparked an absolutely massive legal showdown. Welcome to this explainer. Today, we're diving deep into a fascinating courtroom battle between the South African state and the agricultural free market over the FMD vaccine monopoly. Here's our quick roadmap for today. We'll start with the FMD vaccine battle, move into the courtroom showdown, then break down the Section 10 compromise. After that, we'll look at the remaining market restrictions, and finally, the road ahead. All right, let's jump into part 1, the FMD vaccine battle. So, at the very core of this explainer is a huge clash of philosophies on how to handle a national crisis. For the longest time, the South African Department of Agriculture, acting through the Director General, held a super strict line. To them, FMD vaccination is a quote-unquote controlled veterinary act, meaning it requires direct state authorization and can only be done by authorized people acting on the director's specific instructions. But on the flip side, agricultural groups, the actual farmers out there on the ground, they've been demanding the right to unsupervised private vaccination. They basically want the freedom to buy and administer vaccines through the private sector right now, without waiting around for government red tape. So as you can see, this isn't just a squabble about farming practices. It's a really profound legal dispute over property rights, risk management, and the actual capabilities of the state.
Which brings us to part 2, the courtroom showdown.
To really grasp how urgent this got, we got to look at the timeline. Back in December 2025, Minister of Agriculture John Steenhuisen actually committed to publishing a scheme to fix these exact issues. The deadline? End of January 2026. Well, January came and went, and crickets. No draft scheme. So, feeling the intense pressure of potential outbreaks and, frankly, massive economic loss, the agricultural groups hit the gas. By March 2026, groups like Sakeliga, Saai, and Free State Agriculture decided they were done waiting. They launched an urgent application in the Pretoria High Court to legally force an end to the state's obstruction of private vaccine procurement. The sheer speed of this litigation tells you everything you need to know about how critical this bottleneck is for farmers.
And then we get a moment of pure legal drama. Literally right up until the morning of the hearing, the state was fiercely fighting this idea of private vaccination. But at the very last second, the minister's legal team dropped a supplementary affidavit. And attached to this totally last-minute document was the holy grail the farmers had been demanding, a draft scheme under the Animal Diseases Act. Just like that, the entire landscape of the court case flipped on its head. You just have to appreciate the irony here. It's pretty great. After this 11th hour draft scheme miraculously appeared, Sakeliga put out a statement with this incredibly sharp, dry observation. They said, "The minister's ability to deliver shows significant improvement in the face of litigation." It's a slightly humorous but incredibly pointed reminder of how a court summons can suddenly, speed up a slow bureaucratic process. All right, moving on to part 3, the Section 10 compromise. So the Pretoria High Court stepped in and handed down an interim order based on this newly surfaced plan. Let's break down what this game-changing document actually is. The draft Section 10 scheme is a proposed legal framework nested right inside the existing Animal Diseases Act. And, for the very first time, it proposes letting private veterinarians who are hired directly by the farmers themselves direct the administration of FMD vaccines without the state breathing down their necks. This is a massive paradigm shift. It essentially lifts the heavy operational burden off state veterinary services and places that trust squarely into the private sector. Here's how that shift in power would actually look on a typical South African farm. Step 1, you, the livestock owner, go out and appoint a private, registered vet of your own choosing. Step 2, that vet then directs the unsupervised administration of the vaccine to your herd. It's huge because it empowers the farmer to act immediately to protect their animals using private sector professionals instead of just waiting in line for a slow, state-run rollout. Sounds like a total, absolute victory for the free market, right? While maybe not entirely. That takes us to part 4, remaining market restrictions. While the farming groups were definitely happy to see this draft, they were also quick to point out that we're not looking at a totally open, unregulated free market just yet. Sakeliga raised some serious red flags when they read the fine print of this draft Section 10 scheme. For starters, vaccine importation, still completely centralized. Next, procurement and distribution still have to filter through a state committee structure. So it's not a true free market procurement model at all. And perhaps the biggest sticking point for farmers, the scheme reserves sweeping powers for the minister. Basically, the minister could publish new control measures and effectively snap centralized state control right back into place at any moment. So while actually giving the shot is being privatized, the supply chain itself is still heavily guarded by the government. Because of all those tricky little details, the Pretoria High Court wasn't about to just let the state walk off with a rough draft. They put their foot down and set a hard, legally binding deadline. April 17, 2026. By this exact date, Minister Steenhuisen is officially ordered by the court to publish the finalized regulations for the scheme in the Government Gazette. So the clock is quite literally ticking to iron out those restrictive details. And finally, part 5, the road ahead. So the interim order is out, the state has to cover the costs of the application, and the deadline is locked in. But guys, the overarching debate about how much control the state should actually give up, that is far from over. It's super important to understand the state's side here because their worries are rooted deeply in international trade laws. Minister Steenhuisen actually welcomed the court's decision not to grant the totally unregulated immediate free-for-all the applicants originally wanted. His argument is that unregulated private procurement outside of a national framework is just too dangerous. For him, it's all about ensuring South Africa's response to FMD remains credible, coordinated, and legally compliant to protect both the national herd and the export markets. And to put that into perspective, international export markets demand absolute strict traceability. If a trading partner even suspects South Africa has lost track of vaccine integrity, they will ban South African beef exports in a heartbeat. That would absolutely devastate the economy. So the state's argument is essentially, we have to maintain these safeguards. What's really fascinating to watch as we look ahead, though, is how the state's seemingly united front has kind of fractured during this lawsuit. The alliances are definitely shifting. Two major state entities, Onderstepoort Biological Products and the Agricultural Research Center, actually completely withdrew their opposition to the matter and basically just said, we'll abide by whatever the court decides. On the other hand, the political and administrative heavyweights, The Minister of Agriculture, the Director General, and the Director of Animal Health, they are standing firm. They are continuing to fight against this broader push for a fully unregulated market. Which brings us to the key dates you definitely need to remember from this explainer. As we mentioned, April 17th, 2026 is that critical gazetting deadline where the minister has to publish the scheme. But right after that, on April 28th, 2026, everyone heads right back to the High Court. This second hearing is going to specifically focus on the lawfulness of the minister's final measures, and Sakeliga, Saai, and Free State Agriculture have made their stance crystal clear. If that final scheme still has what they consider unlawful hurdles to private procurement, they are going right back for further legal relief. It's honestly like watching a high-stakes tug-of-war playing out in real time, right at the intersection of private enterprise and national biosecurity. And it leaves us with one massive question as we count down to April 28th. Will the final scheme actually find that perfect balance between the state's absolute need to control a devastating disease to keep export markets happy and the free market's demand to efficiently protect their own livelihoods? Or are we just setting the stage for an even bigger legal war over the future of South Africa's agriculture? Thank you so much for joining me for this explainer, and you can bet we'll be keeping a very close eye on the courts this April.
Summary.
Serious, grounded, foot and mouth disease is a highly contagious, existential threat to South Africa's agricultural sector. A single outbreak can devastate a national herd and completely shut down lucrative international beef export markets overnight. For years, South African livestock owners were forced to watch this threat loom over their farms, while having zero legal authority to proactively vaccinate their own animals. The government had rigidly classified the administration of the FMD vaccine as a controlled veterinary act. Under this strict categorization, a total state monopoly was born. Only authorized government personnel could legally source and administer the medicine. This framework effectively stripped farmers of their autonomy. A farm's survival was entirely dependent on the speed and efficiency of a central government bureaucracy, leaving herds highly vulnerable when the virus spread faster than the state could respond. The tension broke when agricultural advocacy groups launched an urgent High Court application to tear down the government's obstruction of private vaccine procurement. The Pretoria High Court responded with a landmark interim order, officially halting the Department of Agriculture's blockade on the private sector. The court handed down a strict mandate to Minister of Agriculture John Steenhuisen. He was ordered to publish a finalized scheme permitting private FMD vaccinations by April 17th. By forcing the state to relinquish its exclusive authority over the medicine, the court order created the first legal pathway for farmers to directly intervene and protect their own herds in an agricultural crisis. To comply with the litigation, the government drafted a Section 10 scheme under the Animal Diseases Act to outline exactly how this private vaccination process will function. The procedural win for farmers is clear. They can now legally appoint private veterinarians to direct the unsupervised administration of FMD vaccines on their farms. Minister Steenhuisen defended the broader structure of this drafted scheme, arguing that while private administration is now allowed, the state must maintain overarching management of the crisis. He specified that without strict government oversight, the country risks losing vaccine traceability and product integrity, which could severely jeopardize South Africa's compliance with highly regulated international export markets. The state views this framework as the ideal balance, granting farmers the access they demanded, while keeping the vital, centralized disease control required to protect the national trade economy. But the advocacy groups who fought for the court order immediately reviewed the draft and warned that the framework creates an illusion of independence. The critical flaw is medicine importation. The scheme centralizes all vaccine procurement through a state committee, rejecting a free market. Furthermore, it retains sweeping executive powers, allowing the minister to publish control measures that re-establish total state authority at any moment. Winning the freedom to inject vaccines on the farm means nothing if the state can deliberately choke off the supply chain at the border. For a farmer facing a rapidly spreading outbreak, this procurement bottleneck presents an immediate, practical danger. Every week spent waiting on a centralized committee to clear a vaccine shipment puts an entire herd at risk. The timeline to resolve this is extremely tight. By April 17th, the court-mandated deadline, the minister must finalize and publish the regulations for the scheme. Then, on April 28th, all involved parties will return to the High Court to scrutinize the legal validity of those exact finalized measures. If the official gazetted scheme still relies on a centralized state committee to bottleneck procurement, the legal fallout will be immediate.
The advocacy groups have already committed to seeking further interim relief to shatter the state's monopoly entirely and secure unhindered private sector purchasing. The court's eventual ruling on this scheme will define who holds the power to protect a herd, the state committee at the border or the farmers on the ground. Its resolution dictates the future security and autonomy of the entire South African livestock industry.